We're just getting the slides ready, but first of all, I'd just like to introduce myself. I'm Scott Lucyk. I'm at Lawson Lundell in Vancouver. I'd like to thank everyone for joining, which I think is going to be a fantastic panel. And first, I'd just like to introduce who we have on the stage here. First to my left is Caline, Mouawad, who is a partner at Chavis Lindsay in New York City, so thanks for coming up. Caline's a well-known lawyer who represents clients in international commercial and investment disputes all around the world, and also acts as arbitrator. Among her many roles, which we'll be discussing a bit today, Caline is also a member of the ICC Task Force on Corruption and International Arbitration, and she'll be addressing some of the work of the task force later on. Next, we have Andrea Bjorklund, who is, I'm sure, familiar to almost everyone in the room. Professor Bjorklund holds the E. Fortier Chair in International Arbitration and International Commercial Law at McGill University. Andrea also sits as arbitrator, including on ICSID panels, and she's widely published in international investment law and disputes. We have Ekin Cinar. Ekin is a dual qualified lawyer, Ontario, Istanbul, and she practices at Denton's in Toronto. Her practice focuses on international domestic arbitrations. And I'm also proud to say that Ekin is on our In Canada Events Committee for ICC Canada, and so thank you for all your work on that, Ekin. It's been great. And last but not least, Artem Barsukov is a partner at Bennett Jones in Edmonton, where he has a global arbitration practice, and he represents clients from all over the world in high-value disputes. Artem is also on the roster of arbitrators at VANIAC and the SEC. So that's our panel today. Just for some road mapping, our session today, is it still working? Yeah. The session today is going to be in two parts. First, Caline's going to briefly give some insights and maybe some secret information on what the ICC Task Force on Corruption and International Arbitration is up to, and including a recently released documents on red flags with respect to corruption and international arbitration. And then the main bulk of our session today is going to be focusing on the questions, and you should all have access to them. They will be coming up, which are going to really hopefully act as conversation starters and allow you to take away some practical insights and things that you can take back from your practice in the event that unexpectedly or expectedly corruption issues arise, that you're ready as practitioners to deal with them and identify them. Now, very briefly, I'd just like to introduce why are we talking about corruption today, apart from just being a very interesting topic that everyone loves to talk about. I mean, the practical reason is because corruption allegations are increasingly common in commercial cases and investment treaty cases. Now, corruption can take several forms. Most classically and most commonly, we are talking about a public official who's been bribed directly, often with a contracting state. It also may appear as trading and influence, where there are intermediaries involved, agents, consultants, who are also impacting decisions, often of state actors, to contract. And while there are, and we'll talk about this, there are many treaties and obviously domestic laws dealing with corruption, there is also a developing body of international public policy that international tribunals are applying, and also, as we'll talk about in the context of enforcement under the New York Convention, public policy issues that are increasingly becoming relevant and that we should know about. Now, one of the most well-known cases discussing this was the World Duty Free versus Kenya case. And that case was a commercial case, but it involved a sitting head of state who received a briefcase of money in Dubai, and then there was an arbitration that arose. And without getting into all the details of the case, what I think is quite interesting is the tribunal noted that international public policy in respect of corruption signifies what they termed an international consensus as to international standards and accepted norms that, and then very importantly, must be applied to all fora. And they described this international public policy against corruption as not only protecting the litigating parties, but also the public, often tax-paying citizens in some of the poorest countries in the world who may be adversely impacted by contractual agreements that are facilitated by corruption. And shortly after that award in 2006, Constantine Partizaitis, who was counsel for the Republic, he was reflecting on that decision, and he noted at the time, he said, it was an unusual decision in unusual circumstances because, as some of you may know, the claimant itself offered the evidence of the bribe. But in 2000, so almost 20 years ago, he asked the question, is international arbitration, or international arbitration practitioners and tribunals ready to deal with less obvious cases? Are they ready to deal with tacit cases of corruption? And I think today, I think what the message will be is that while there are still divergent positions and still certain areas of the law that are being settled, there are increasingly frameworks that tribunals and practitioners can rely on, including ones that are being generated by the ICC, to help address these tougher issues. So very briefly today, we'll be discussing how to prove corruption as counsel, the arbitrator's role in investigating corruption, the interplay of criminal proceedings and arbitration proceedings, and the impact on enforcement. So with that, we will start the first substantive section, and Caline will give some comments on some of the really important work that has already come out, but that it is to come out from the ICC task force. So thank you, Caline.
It's working? Yes. Great. Thank you, Scott, and thank you to the ICC and CanArbWeek for having me here. I'm always very excited to talk about the work of the task force. The genesis of that task force is precisely what you noted, which is sort of this international consensus that corruption is bad and that we don't want to be perpetrating and facilitating that or rewarding it through arbitration, but that how tribunals approach those questions is unsettled. And so the idea behind the task force, which was established in November 2019, right before COVID, was to try to examine those issues, to try to see if there was some guidance that could be given to tribunals and how to deal with these kinds of questions when they come up. And the task force has been proceeding quite methodically. After it defined its mandate, its scope of work, and its approach, they set out in detail a detailed list of the procedural and substantive issues touching on corruption. But given the magnitude of that work, the task force has been focusing on the procedural questions first. And so the way it's organized its work is through various tracks that have specific topics that they're investigating. And those tracks are composed of task force members, and they're led by coordinators. And the way that it's shaping up, and I'm sorry if you guys already know this, but I was told I could give some background as to the work of the task force, is each of the tracks is aiming to, or has been working on, or has already authored a working document that would serve as guidance and as a reference for practitioners, both counsel and arbitrators, with case references, et cetera. And then that information would feed into an umbrella report that would sort of summarize the key takeaways from the work of the task force, and where appropriate, provide some guidance. And so what we have here, the first work product from that track is this document, the red flags or other indicators of corruption in international arbitration. Don't leave home without it. You can find it online. And it's a very detailed report about red flags. This was issued at the end of last year, about red flags and how to identify red flags, how to assess them, validate them, figure out what they prove, what they don't prove, what are their limits, et cetera. I won't say more than that because it's coming up in our panel discussion, so I don't want to take away from that. But it is a very useful tool, and you'll hear more about it in a moment. The other tracks are continuing their work and nearing the end. I would just highlight for you, given the topics that we're going to discuss today, there is a track on the burden and standard of proof There will be a working document. There's a track on arbitrator duties and a track on parallel proceedings. So actually all the topics that we're addressing today, there are working documents in the works. So stay tuned for hopefully additional publications coming this year or later this year. And then in terms of the umbrella report, that's also in the works with the goal of producing a draft for the commission, the ICC commission, to review at its meeting in October in Toronto. So stay tuned for more information on that front as well. Thank you.
Well, thanks, Caline. And I do actually highly recommend people do look at that document. It's a wealth of information, and there's been a lot of really great work, great people working on it. So I do recommend people having a look at that. If I could ask if we could get the third slide. But anyways, while we're just waiting for that to come up, you should all have it in your handouts. What we're going to do now is we're going to switch into dealing with some of these practical issues through what we hope are short and bite-sized fact patterns that will help spark discussion and maybe some thoughts. Fantastic, yeah. You have the magic touch. I'm not sure. I'm going to try a way to blame AI, Janet. So this first topic addresses issues that may arise in proving corruption. So I'll just read it briefly. It says, in an international commercial arbitration, a company brings a claim against a state-controlled oil company. Prior to the contract being signed, the CEO of the claimant made a political donation to the state's Minister of Natural Resources. The three-member tribunal includes arbitrators from civil and common law backgrounds. So the question for you as counsel is, as the lawyer for the state-controlled company seeking to prove corruption, so as defendant, as respondent, what would you do? And to help lead that discussion and provide some answers, I'm going to ask Ekin to...
Of course, thank you. Who wants to deal with a fact pattern at 9:22 on a Tuesday morning? Obviously, I will explain my own ideas, and I'm not stating anything in relation to my firm. That's just me talking about this fact pattern. And maybe before delving into a fact pattern, I should start by explaining the concept of red flags. Caline briefly mentioned of the three-step methodology, and to understand this methodology, you have to be working with the red flags. Allegations of corruption, particularly bribery or donations, as in this case, they're just popping up way more often in arbitration cases. And as you know, and anyone involved knows, proving these things that happened in the shadows, maybe hidden under the table, it's incredibly difficult. You don't have that clear proof, that smoking gun you need. You rarely find those examples. So this is where this whole concept of red flag becomes so crucial. Red flags are not themselves proof, but they're powerful indicators. They are warning signs, and they point to a potential risk. And you know, getting a handle on this topic is vital for anyone navigating international disputes, and this is maybe because it just feels so opaque, like it's definitely complex. And the ICC Commission document on red flags provides us with a very helpful roadmap, and the starting point is the red flag, as I said. So it says any fact or circumstances that indicates a potential risk of corruption. But red flags aren't just this general sense of, oh, something smells fishy here. They are meant to point towards a specific legal test or elements of a particular corrupt act. And before you can even really interpret a red flag, you need to know what specific crime or corrupt practice you might be dealing with. Maybe you're dealing with a transnational bribery issue, and you are using the definition under the Anti-Bribery Convention OECD. So you need to know the required legal elements of the corruption. And it's just vague suspicion, right? It's a specific fact pattern that looks like it could line up to a potential bribery or whatever the specific corrupt is. The document then breaks these flags down to two broad categories. The first one is general red flags. These are the sort of characteristics like the country where the business is happening, or maybe the specific region, the government administration you're acting with, or even the industry itself. But be cautious. You absolutely cannot take these general flags at face value, relying only on things like country risk, for example. You have to be critical. You have to just look at the actual corrupt act. So just to say, general risk isn't proof of specific wrongdoing. And the other basket is specific red flags, right? These are much more granular things. They're tied directly to the particular parties involved, or maybe details of the transaction itself. And if you can validate those things, they tend to carry a lot more weight in an ex post assessment. Things like maybe an overly close relationship with public officials or non-transparent corporate structures. Think of shell companies, layer after layers. You can't really understand who's behind it. Or a really classic example, as Scott mentioned, it's hiring third parties or agents. And when you look at them, really, they just lack the required qualifications for the job. The Alcatel case is quite well known in this example because some of the agents involved were essentially perfume salesmen, and they were tend to land those very complex telecom deals. So you question the expertise they have. Just to finish with the colors of flags in this document, I will mention the green flags. They just suggest the absence of corruption. They're often linked to things like having really robust corporate structures so that you can mitigate these acts before they happen. They are important because green flags can offer an alternative explanation as to what happened really in that case. Okay, now we have the different flags and different categories. I think we can now discuss the three-step methodology and approach this fact pattern from this perspective. The first step in your roadmap is to identify the flag. It's the initial point, and it's like this little warning light in the dashboard and blinking and giving you the signal something is happening there. In this fact pattern, as you will see, the CEO of the claimant company, prior to the contract being signed, made a donation to the Minister of the Natural Resources. The Minister of Natural Resources is probably someone who likely had influence over the state-owned oil company and its procurement decisions, so it's one red flag there. And the timing is also off, right? It's just happening prior to the signing of the contract. Maybe it suggests some sort of a quid pro quo. The fact pattern didn't say, but maybe there are some green flags in this situation. Maybe the donation was publicly declared, right? And maybe it was made through proper financial channels. So that was step one. Step two is validating, and this is when the real detective work comes into play. You are checking if this little blinking warning light is real. That's the ultimate duty for the second step. How do you do that? How do you validate those flags? Well, it's about digging into all surrounding circumstances, like we mentioned, checking both green and red flags together, maybe checking the background and qualifications of these perfume salesmen in the Alcatel case, right? Maybe they have some sort of a hidden expertise that we don't know. You can check the corporate structure. Is it a legitimate entity, or maybe it's just a brass plate somewhere in an offshore haven? We don't know that, so you really dig into those details. You can also check whether the payment is unusually large, or it was routed in a strange way. Or the payment made was linked to a service that was not well defined in a contract, or there is no proof of work that was done. So in our fact pattern, to validate the red flag, the respondent would probably consider, I think, if they have or can get any documents. And I'm thinking about internal communications, board minutes, correspondence between public officials, government officials, bank statements, receipts, anything that can give you some validation. Maybe the respondent can see a receipt for the donations. And depending on where you are in the arbitration, cross-examination can be a helpful tool, right? To learn about the timeline and the relation between the donation and the contract negotiation. So you might want to look into that. Another factual point you can consider is the circumstances of the contract being awarded. Maybe the contract was awarded through a publicly transparent procurement process. Maybe the standard procurement practices in that region were followed. And last two things I can think of for this second stage, as if I am the respondent counsel, is to consider whether I hire an expert, right? Maybe a forensic expert, just to trace the payment, as they say, or a political finance or anti-corruption expert that can give some more substance to this analysis. The last stage is after you identify, flag the potential issue and validate the underlying facts, is the assessment. It's an holistic overall assessment of the big picture. You look at all the validated facts, all the validated flags together, and you consider their individual strength or quality, and you weigh them against any green flags that we mentioned. And the ICC document is very clear on this point. You cannot just add them up like points on a scoreboard. It's a very nuanced assessment. And to do this assessment, the ICC document refers a concept from French law. It's this concept of faisceau d'indices suffisamment grave, précis, et concordant. So I'm just gonna give the details of those three things that I mentioned in this rule, and I will leave the floor to the second fact pattern. So we are seeking for an indicator it is serious enough. And in this context, serious means the indicator has a direct and strong connection to the actual legal elements of corruption that we discussed at the beginning. What about precise? Well, precise means the indicator is just not this general thing. It has specific verifiable details, and it's directly relevant to the ultimate issue of whether the corruption happened or not. So it's not just high fees, it's validating that the consultant charged a fee of maybe 3 times higher than the industry standard for that exact type of service in that specific region. And finally, concordant, which means that they all point the same way. Everything you found point the same way. The validated facts and the indicators shouldn't contradict each other. They should build a collective narrative, a consistent narrative that suggests that the legal elements are there.
Well, I'd like to thank Ekin for doing the impossible task of briefly covering a corruption analysis and introducing all the concepts. So, but we do have a bit of time before we go on to the next topic. So I just wanted to open the floor maybe to anyone who wants to act as claimant's counsel or who has any questions about the methodology that Ekin introduced.
Doug Jones, one of the issues involved in dealing with proof is the question of the witnesses who might be called by either side in a debate such as this. I had 2 fairly major arbitrations seated in New York involving the Lava Jato issue in Brazil, defended by Petrobras on the basis that the contract was unenforceable due to corruption. And the witnesses who were called on both sides were, at the time the hearing proceeded, the subject of investigations in Brazil by the police force given the responsibility of prosecuting the Lava Jato affair. And we had to put in place in the arbitration a ring fencing of the evidence of these witnesses, because they were, many of them, subject to deferred prosecution agreements or other plea bargains that were underway in Brazil. So we had to give each of them the right to their own representation in terms of potential self-incrimination, and we had to excise from the ICC award our findings in relation to the issues associated with their evidence in order to ensure that it never went to Brazil, which meant that we had to ensure that ICC scrutiny involved no one from Brazil. So the issue of what you might call parallel proceedings in this context is a really important one, or else the arbitration process can be derailed forever, depending upon the time it takes for the local authorities to deal with the allegations of corruption.
Sorry, just to follow, I'm just curious, did the question of staying the arbitration come up pending the criminal proceedings?
Yes, but if we'd stayed the arbitration, we'd still be waiting. We had to proceed, and you have to find a way to proceed which ensures a balancing of the rights of the individuals and a protection of their material from subsequent use in the parallel proceedings.
And, oh, is there a microphone? We have one question over here.
Yes, thank you very much. My question is this, and it's not unrelated to the comments made by the previous speaker. In a situation like this, where allegations of corruption are floating about surrounding an arbitration, to what degree do the participants therein enjoy, if indeed at all, any of the kind of normal constitutional protections that are true, for instance, say, in criminal proceedings in Canada? For example, the right not to have to incriminate oneself, for instance.
I don't have the exact answer for you off the top of my head, but I mean, I think one issue that the party seeking to prove corruption will face is if they can't get the witness and they can't get the evidence, that they may face adverse inferences. So from a strategic point of view, that is likely the trade-off if they can't get people or the evidence in front of the tribunal.
Yeah.
Yeah.
Sorry, I mean, this is actually the heart of what's happening with the track on parallel proceedings for the ICC task force, is exactly wrestling with those kinds of questions about self-incrimination, how to protect, whether the evidence that emanates from the criminal proceedings should be permitted into the arbitration, and vice versa, sort of how porous that wall is. So there's a lot of uncertainty about that this report is wrestling with. I'm giving you guys some insider information. That's okay. And the hope is that we'll be able to give a little bit of structure to that analysis, perhaps not a definitive, this is what you should do, but you should consider XYZ factors as you're assessing, as the tribunal, assessing what to do about that evidence, how to protect those rights, how to make sure that the person is able to give the evidence truthfully without it, self-incriminating, etc. So it's not an answer, but I feel like there's something coming in that space. So keep your eyes peeled.
So we're going to move on to the second issue. If we could switch the slide as possible, I'll read it. So this question has to do with the tribunal's role in investigating corruption. It says a company brings a contractual claim against a foreign state for $70 million. Documents submitted to the tribunal show that after the contract was signed, the company paid $18 million to an unqualified consultant with business connections to the state's lead procurement issue. No allegation of corruption is made. As one of the arbitrators on a 3-person tribunal, what would you do? And to answer that question, we have Professor Bjorklund.
Thank you very much, and thank you to ICC Canada and CanArbWeek for having me here today. So here we have this situation, a fairly terse hypothetical, where the parties themselves, neither one has raised the issue of corruption, yet in the hypothetical, the red flag, if indeed it is a red flag, it is before the tribunal. So initially, we seem to have two possible responses. One, the tribunal can do nothing and ignore it. Second, the tribunal can investigate it. First, keeping in mind appropriately that this is a red flag. It is not evidence. It is not proof. It is an indicator that might warrant further investigation. So who would do nothing? Excellent, then it makes my life easier and that I don't have to convince you that you have to do something, because indeed I was going to recommend not ignoring it. However tempting that might be in some circumstances. And I think that some of us probably in the room can remember some early arbitrations where there were hints of corruption or even vague discussions or mentions of corruption that somehow really dissipated as the case went on, that never really took off. And it's almost as if there was a general sense that this was just going to be too difficult and maybe we just let it go. I can think of the Metalclad case, Metalclad versus Mexico, where there was an allegation that maybe there'd been a payment made to a federal official. That allegation was made by Mexico, but it ended up not playing a real role in the case. And it seems to me that it didn't really make its way into the award. And there could be many reasons for that. But at least in a sense, it was going to be difficult. It made Mexico look bad as well as making the claimant look bad. And I think there wasn't really proof, at least as near as one can tell from the public documents. I don't think that's 25 years ago, even a little more than, good Lord, a little more than 25 years ago. I don't think we would be there today. Although there are these questions when you're looking at the duties of the tribunal as to where the tribunal's duties arise and just what the function of the tribunal is. So you'll see in some of the literature discussions about the jurisdictional, so-called jurisdictional versus the contractual approach to arbitration. The jurisdictional approach usually being described as when the tribunal exercises quasi-judicial functions and thus has a role to play with respect to broader kind of international rule of law issues, including the fight against corruption. The contractual approach, meaning the tribunal's only job is to resolve the dispute between the parties, not to make the dispute more complex or difficult or dismissible. In reality, and so that was the situation for, I think, some years in the early 2000s where there were fairly strong views kind of on either side of that. But I think that difference has largely dissipated. And in recent years, there's quite a lot of coalescence in those approaches. You have more rules that more clearly authorize arbitrators to engage in sua sponte investigative activities. Corruption is even more universally condemned. The kind of approach of, well, in some places this is just what happens, is less accepted. The desire to have an enforceable award is equally applicable in the contractual context as in the so-called jurisdictional context. Even the cases that support this so-called contractual approach where arbitrators were inclined not to investigate corruption or appearances of corruption was not necessarily because they thought they couldn't or shouldn't, but because they did and found the evidence was too thin to warrant further progress. So it's sometimes, I think, easy to try to impose a pattern on what are still not that many publicly reported cases, whereas in fact each case has its own particular factual context and might give rise to a decision that is supported by those facts, not because of a general approach. But to the extent the contractual approach was supported in any way by arbitrators' concerns that they lacked the authority to decide something that was not kind of directly placed in front of them by the parties, that concern has largely dissipated. And in fact, there are now, it seems, multiple sources of an arbitrator's tribunal member's duty. I'm going to focus mostly on legal duties, but perhaps there are moral duties as well with respect to investigating these matters. In the first instance, and just I mentioned it first because in a sense it happens, it is likely applicable regardless of where you are or where you're sitting, and that is the standards applicable to individual members based on their bar licensing, assuming the tribunal members are lawyers. And the UK, I think, is the jurisdiction that is most notorious for this, that you have obligations under UK law to report, to kind of report suspicions of corruption, so that is something to consider, certainly. But you also have arbitral rules, and we've had, Caline talking about the ICC rules. More and more arbitral rules give tribunals either the explicit authority to investigate corruption allegations or the explicit authority to investigate matters that they think warrant further investigation, which could easily involve corruption. You potentially have obligations conferred or powers found in the place of arbitration in the law applicable to the merits. There is something of a debate about whether arbitrators truly have a duty to render an enforceable award, or whether what we normally refer to about the duty to render an enforceable award is really a coalescence of all kinds of other responsibilities. But certainly, I think arbitrators do have a duty to think about the effects of their conduct of the proceedings on the enforceability of the award. And if anything, the P&ID case, P&ID versus Nigeria, the notorious case out of the United Kingdom a couple of years ago, gives us the encouragement that certainly UK courts believe that arbitrators have a duty not to bury their head in the sand. I'm not suggesting that that's what those arbitrators did, but that is the implication of that court decision. We've talked about public policy. So public policy participating in the fight against corruption is another potential source of a duty, and certainly the authority to do something. And I think, and given what happened when I asked for a show of hands earlier, the expectations in the arbitral community, I think, are important as we're deciding what to do, what it is that an arbitrator should do. So while it's always going to be subject to the arbitrator's judgment about how strongly to pursue a red flag and how much evidentiary weight to give it, ignoring a clear red flag seems inconsistent with both the likely applicable law and rules and the expectations of the parties and the arbitral community. So if we look at our particular fact pattern, as the ICC task force very usefully directs us, the first job is to identify the potential asserted red flags. And in this case, we have this slight anomaly that the payment was made somewhat after the contract was secured. But when I say need not detain us and does not excuse us, so the fact that the payment postdated the issuance of the contract doesn't insulate it from scrutiny. So you can consider and the ICC report helpfully says, red flags in the context of a dispute point to some kind of corruption risk can be considered in an ex post context. We have a specific red flag here tied to this transaction. We were given a very terse hypothetical, so we have an apparent overpayment for services vis-a-vis the value of the contract, which is alarming. Excessive compensation is a strong red flag. Now, in this particular context, we do have a question about what type of corruption this could be. Is this direct corruption, or when I say merely influence peddling? Could it be a rather expensive consulting contract? Could it have been bad business judgment? It could be among all of those things. Maybe the expectation was that the contract would have been worth a great deal more, and that hope was dashed at the end, in the end result. It could be influence peddling. I think Scott mentioned influence peddling, which might or might not be unlawful in a given jurisdiction. Some of you know I am originally American, so influence peddling, it seems, happens and is apparently not unlawful in certain jurisdictions. Here, in this particular case, there's the clear possibility of a pass-through payment to a government official, which would evidently violate most, I think, bribery laws, both domestic and international. That's one of the factors that almost certainly warrants more investigation. You would want to look at whether there were other red flags tied to the country or to the industry. But keep in mind that the red flag is, as Ekin said, it's only a red flag. It is not evidence. It is not the only thing that one must consider. So one has to validate or confirm the red flag and or negate the red flag. We've been given this hypothetical that this is an unqualified business person, but people have to get their start somewhere. Maybe it was a bona fide contract. Maybe there were, I'm going to say, valid reasons for that. And I think Doug has told us about a very complicated case, but certainly the arbitral tribunal in investigating has to keep in mind the rights of the parties to have due process and to have make arguments about what this means, what the result of this contract should be, and what the circumstances surrounding it were. I'm going to stop there so that we have time for discussion, and just thank you again for your attention, and turn it back over to Scott.
Thank you, Andrea. We're going to have to take questions after the next session, just because we're bumping up a little bit about overtime. No problem. So, Artem, if we'd like to move to the next slide, that would be fantastic. So this involves some of the issues that Doug and others have already raised with respect to parallel proceedings, not particularly the issues around evidence giving, but some of the tricky issues that the task force is dealing with. So I'll read this quickly. It says, you are acting as the respondent's lawyer in an international commercial arbitration. On the eve of the merits hearing, the claimant's CEO is convicted following a high-profile criminal investigation for corruption in relation to the agreement. As a respondent's lawyer, what would you do? And again, we've tasked Artem with the very difficult task of explaining all this in a very short period of time. So thank you, Artem.
Thank you, Scott. Is this working? Awesome. So good morning, everyone. And my notes have flown away. Perfect. First of all, I'd like to join my fellow panelists in thanking ICC Canada and thanking CanArbWeek for giving us an opportunity to present our views this morning. So my scenario, admittedly, is a little bit simpler than the ones that Andrea and Ekin dealt with. I'll split my answer into two parts. I'll talk about the concepts at play, I'll speak about it conceptually, and then I'll give you a rapid fire of hard-hitting practical tips on how to approach this specific scenario. Conceptually, I won't spend much on this because Ekin and Andrea have done such a tremendous job already talking you through the red flags and the various steps involved based on the ICC paper. One thing I will say is that even though it's a conviction and it's a very clear-cut case, seemingly, for the purposes of the arbitration, this is still only a red flag. It's a parallel proceeding that is its own proceeding under its own standard of proof, under its own procedure. There may be questions about how clean the proceeding itself was, depending on their jurisdiction, whether it was a political prosecution or a genuine criminal case. So for the purposes of adjudicating corruption in the context of the arbitration, this is merely a red flag. Admittedly, a very bright, glowing red flag, since we actually have a conviction, but nonetheless, you still have to go through all of the steps of validating the red flag, evaluating the red flag, and finally weighing the evidence. So this is where I'll switch to the practical steps once you've hit with this news of a conviction in a high-profile investigation. To me, I don't think it's overselling it to say that this is like lobbing a live grenade into the hearing room. The dynamics of the hearing fundamentally shift. And as respondent's counsel, I have a unique opportunity to really turn the hearing around. If I'm on the losing side of the merits argument, I can leverage the authority in World Duty Free to argue that the tribunal should not even entertain the claims advanced under the agreement, because to do so would be to essentially give effect to an agreement that's been tainted by corruption. If I'm on the winning side of the merits part, I still stand to save substantially in terms of cost and effort to my client, and not having to argue all of the merits of the contractual dispute, by instead raising corruption as a threshold issue to admissibility and jurisdiction in line with cases like World Duty Free and Metaltech. So I'll stop there and I'll turn the floor over to you, the audience, and my fellow panelists. Do you find that in the recent years, tribunals deal with corruption more as a threshold issue going to jurisdiction and admissibility? Anyone? All right.
Well, maybe just we'll use as a stopping point, just to open it up to any questions with respect, or any comments with respect to this fact pattern, or anything that arose out of Andrea's discussion. Does anyone have any burning issues, questions? I think we have one.
So this actually goes back to Professor Bjorklund's comments. And I do want to preface it by saying that I have some understanding of these types of cases based on more on my counsel practice, where I had a number of cases involving bribery and corruption, including cases in which I acted for a party that was accused of bribery and corruption, and on behalf of a state that was pursuing claims for bribery and corruption. So I'm not asking the question from the point of view of not having some understanding of these fact patterns. But as I understand question number 2, you have a situation where you've got a red flag. It's a pretty good red flag. It's a very common red flag. We've had situations in Canada that parallel this exact fact pattern. And in some industries, it's pervasive that you will find these kinds of consulting agreements. And you can almost wonder whether any transactions take place without these kinds of consulting agreements. So it's quite widespread. Now, what you're saying, though, is here's a situation where we have this red flag. I'm assuming the information is available to the parties, as well as to the tribunal. The parties have chosen not to raise it with the tribunal. And you're suggesting there's one member as one member of a 3-person tribunal, there's a duty on that arbitrator to pursue this red flag and initiate some sort of proactive investigation or steps in relation to that. In terms of where these duties come from, is there any consideration given to the personal safety of the arbitrator on whom this duty falls? Because to me, that is really where the rubber meets the road. I mean, people may make different choices, but ultimately, you know, if I have to hire a bodyguard, is that a cost of the arbitration, you know, that I can pass on to the parties? No, so just generally, coming to the crux of it, where does that factor fit into the formulation of these duties?
Well, I can think of people who were in this room yesterday who might have a view on that, because I believe there were threats made in a case involving people whom most of us know. So you know, that is a serious question. I guess I would step back from that to ask whether that arbitration can be going forward if that is a fear. I mean, if that, like, there must be some concerns prior to the indication of this payment that would be. Yeah. Yeah. Right. 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 But so. Yes. 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 Well. Yes. Yes. No. Yes. Yeah. Yes. Yeah. I mean, I think you've raised an extremely, I want to say, difficult hypothetical, but I mean, I honestly would ask you in that case, well, if you're going to decide against the party who you think is going to threaten you, and you're going to make a decision and award against that party, then that would seem to be problematic for the entire arbitration. I mean, I'm having a hard time envisioning a situation where an arbitrator says, this is a problem we would like to raise to the parties, the issue of this contract and what should be done about it, and that in that case, if the arbitral tribunal were going to decide against that party just on the merits, that would not also be problematic from the point of view of arbitral safety. So I guess that's the first thing I would say. The second thing I would say, and maybe this is a situation where if you felt like that, you would have to resign. I mean, if you felt you could not fulfill your duty, then maybe you need to resign from the tribunal. It would be a suggestion. I mean, yeah. I mean, I can say you can do nothing and you can wind up in front of Mr. Justice Knowles in the United Kingdom, and then you will be potentially outed when I say anyway. I mean, because I think if the arbitral tribunal has seen this, then presumably at some stage the parties could have seen it, and one party might raise it on set aside. Just saying, it's a possibility, because I think what. Any, Caline, any thoughts? No?
Thank you. I just wanted to go back to number 3 as the respondent's lawyer. So, and I understand these are designed to engender some kind of discussion. So here's sort of my reaction to this as a lawyer. Why are you? It's seemingly you're only finding out about this now, although it's been a high-profile criminal investigation. So in this day and age, I'm assuming there would be some news coverage of this. And so what have you done thus far as the respondent's lawyer to deal with the information that is out there? I wouldn't expect to have waited 10 months or 12 months or 8 months for the conviction to suddenly be in my lap, and then to say, oh, what should I do with that now? I would have expected some ongoing use of the situation. The next question is trying to find out, is the CEO's conduct aligned with that of the corporation? So I don't know, what's the governing law? Identification doctrine is the conduct of the CEO, is it fraudulent conduct? Is the claimant corporation then tarred with that conduct so that I might be able to argue ex turpi, for example, or whatever the system of law that applies to this arbitration might allow me to do? So it just seems to me there's a lot of things you need to do as counsel. And Bill, you know, I share your concern about the arbitrator. I always think as arbitrator, the parties are asking me to do something, or the tribunal, and you do what they've asked you to do. And unless the parties are raising something, I'm not sure I want to stick my head out above the trench line and risk bodily injury, you know, without my bodyguard being present. So those are, I don't know, those are just some reactions to that topic number 3 for what they're worth.
So Scott, with your permission, I can respond to that real quick.
Yeah, please go ahead.
Mike, you raise a very good point. To your, both of which go to some of the points I was looking to make in my response. To your first point about this being a high-profile investigation and why we'd be waiting until the eve of the hearing to raise this, I think the conviction adds an element of credibility, raises it to a higher state of red flag, if you will, because presumably the evidence has now been tested in a court of law and proven on a beyond a reasonable doubt standard. There's still an outstanding question of whether the conviction is subject to appeal and what is the standard applicable to the appeal. If there's new evidence that can be introduced on appeal, then it's not as clear cut. But if there is an appeal and the appeal solely deals with questions of law, then I can make a persuasive case to the tribunal here as respondent's counsel that this evidence of corruption has been tested to the nth degree, assuming the local jurisdiction enjoys solid reputation in terms of its criminal justice system. To your second point about whether the conduct can be imputed to the claimant, if the claimant is the corporation, actually one of my first practical suggestions I was going to put forward to the audience is to take a step back and resist the temptation to run with this and to bring as much of this criminal proceeding into the arbitration as possible to derail the claim. And that is because since World Duty Free, there is a line of case law, such as in Vantage Deepwater and Petrobras from the Southern District Court of Texas, where the courts have actually upheld arbitral awards, notwithstanding allegations that the contract at issue has been tainted by corruption, if there is evidence that the respondent seeking to assert the defense was a willing co-conspirator or otherwise validated the corrupt deal. So I would investigate whether my client is actually wearing the white hat here and to what extent the client has been implicated in this corrupt agreement. So that answers those questions, I hope. And very quickly, because I need to turn the floor over back to Scott, in terms of other very practical steps is, as I mentioned, I'd raise admissibility as a threshold issue. I'd use this red flag as a hook to leverage the tribunal's curiosity and, frankly, duty to investigate this further by seeking extensive document production. I'd seek document production from the claimant to bring in whatever records they have in relation to these corrupt transactions. I would also, to the extent I don't have access to the criminal record in the domestic file as of right, I'd seek the tribunal's assistance to get access to that information, and then I'd use that information to understand the grounds for conviction and bring anything I can as evidence into the arbitration, highlighting the fact that this evidence has been tested on an exacting beyond a reasonable doubt standard. I'd also invite the tribunal, in line with Andrea's comments earlier, to conduct its own inquiry into the red flag and investigate what happened there. And finally, I would either seek bifurcation of proceedings to deal with the issue of corruption first at the threshold issue, or if the tribunal is not minded to bifurcate, I would at the very least seek leave to make further submissions and adjourn the hearing pending further submissions so that the respondent can fully argue the implications of the evidence of corruption in this case. If the tribunal resists this request, of course, I would do the usual surfacing the enforcement risks by failing to give the respondent an opportunity to make full answer in defense. So in conclusion, if you will remember nothing else from today, use the general red flags about the countries and the industries where corruption might be prevalent to watch out for parallel proceedings. More often than not, if there is something out there that you're not aware of, it may very well turn the case on its head and turn a losing case into a winning one, or save your client a whole bunch of grief trying to argue the merits. Thank you.
Sorry, Lisa, we're going to have to pick up your question after. Is that okay? So now we'll switch just to our last topic, because we are running short on time. And this topic addresses the question of enforcement. So I'll just read it quickly. It says, a company is seeking to enforce an international arbitration award. After issuance of the final award on the merits, leaked communications and media reports reveal that the contract resulted from a widespread bribery scheme. As the lawyer seeking to resist enforcement, what would you do? And for some of you, this may ring of some recent cases, but Caline will give her comments on this.
Sure. Thank you, Scott. I'll be brief. I know we're running short on time, but sorry. We're okay. All right. So I think there are three possible avenues for you. One is might be before the tribunal, and the other two are the national courts. So first, on the tribunal. So I know it says final award on the merits, but it doesn't say whether there might be a quantum phase, so that your panel might still be impaneled, and you might be able to come back to the tribunal with some kind of request to reconsider. You might also be under, even if this is a final award, if you're under the, if it's an ICSID case, you have the revision Article 51 of the convention that allows you to go back and ask for revision of the award based on newly discovered evidence, and that requires that allows for that question to be sent back to the original tribunal if possible, and if not, then a new revision tribunal is impaneled, and that can be a way to go back and try to open up the award again. There was a case, I'll just quickly mention it, I think it's Hydro versus Albania, where Albania made a revision request on the basis that there was new evidence of certain illegalities in the making of the investment. That did not go back to the same tribunal. It went to a revision tribunal. And ultimately, the tribunal said that actually Albania knew of these events at the time of the arbitration, so that was not newly discovered, and it denied the request. So just putting that on your radar as a possibility to go back to the tribunal. Otherwise, you're going to be before the courts in one of two scenarios. First would be in a potential set-aside of the award, which you can do under depending on the jurisdiction that you're in, under the model law, you have the ability to set aside the award based on if it's contrary to public policy. And usually it's hard to set aside awards, at least in many jurisdictions like the US. But, and even when there have been some allegations of fraud and corruption, because there's a lot of deference afforded to the tribunal. But if you're in France, you have a really good shot at this. So try to have your seat in France if you're trying to potentially keep that door open. Because the French courts have been quite proactive at looking at evidence, generally looking at jurisdiction and looking at particularly questions of corruption and evidence of corruption. They've been very clear that, first of all, they'll look at allegations of corruption that were not raised before the tribunal. And so they'll look at them for the first time in the set-aside proceedings. That's the Sorolek versus Libya case. And then they will also look at new evidence that was never presented to the tribunal, which logically follows from the fact that they're open to listening to corruption arguments that were not raised before the tribunal. So they will look at new evidence that was never presented to them. And that's the Balakan versus Kyrgyzstan case from 2022. UK courts have historically also been more restrained, but then now, as Andrea mentioned, the PNID versus Nigeria decision, where there was an allegation, this is a $6 billion award, there was evidence that came out subsequently in set-aside proceedings that there had been a bribery of a government official to obtain the contract. Then there had also been bribery of the government official during the arbitration to suppress the evidence of the original corruption from coming out. And so all of that came out in the set-aside proceedings, and the courts set aside the award. I mean, one question that that it raises for me is, if there had not been if there had not been corruption in the arbitral process, would the court have been so proactive? There's something that makes us all uneasy, that the process itself was tainted by corruption, and that, you know, the truth was subverted the way that it was. And that was one of the things, actually, the judge decided not to remand to the original tribunal and instead to set aside the award, because precisely for that reason, because he thought that the whole process had been corrupted. And one thing I would note is that in certain jurisdictions, when the award is set aside, it can be like in this case. Well, this did not happen in this case, but there was the possibility that it could have been remanded to the original tribunal to look at the case again. I know in Switzerland that's always the case. When an award is set aside, it's then remanded to the original tribunal, which can be awkward, but that's a topic for another day. And then finally, you could be in the context of resisting enforcement. So you're not at the set aside, you're not at the seat, but you're trying to resist enforcement on the same basis, New York Convention reason that, you know, the award was obtained, the award itself, enforcement of that award would be contrary to public policy. And you have a line of cases that that shows sort of the contradictions, the different results that courts can reach. So if you take the Alstom case, where it was a bit of a ping pong of decisions on enforcement, it went to the French courts, first of all, to the Paris Court of Appeal, which made its own assessment of the evidence, right? Did not defer. So not only do French courts hear new evidence and new allegations, but they'll also make their own independent assessment of the evidence that is before them, even if it's different from what the tribunal itself decided. So they don't feel bound by what the tribunal has done, and it's a de novo review. And that Paris Court of Appeal found that there had been serious indicators, what you're saying, serious, precise, and consistent indicators of corruption, and declined to enforce the award. That's in 2019. Then in 2020, you go before the UK courts, and the UK courts apply a balance of probability standard, and they say there's insufficient evidence to support denying enforcement. So they enforce the award. So Paris Court of Appeal doesn't enforce, UK courts enforce. Then we go to the French Supreme Court the next year in 2021, and the Cour de Cassation says, well, the lower court has misinterpreted the evidence, and they need to look at it again, and they ultimately remand to the Court of Appeal in Versailles, which that Court of Appeal, when that case goes back to them, I think in 2023, yes, it made its own assessment and found that there was no reason to deny enforcement. So, the Paris Court of Appeal denies enforcement. The French Court de Cassation says you misapplied the standard, or you misinterpreted the evidence, not misapplied the standard. You misinterpreted the evidence, and the Versailles Court of Appeal then says we can enforce. So, kind of a ping pong of enforcement decisions within the same jurisdiction and across the pond as well. And with that, I'll turn it back to you.
Well, first of all, I'd just like to congratulate my panelists for leaving a bit of time. That's truly a work of wonder and art, so thank you. But we do have a couple more minutes for some questions on anything, even tricky ones as we've already had, if anyone has any thoughts or comments on any of the particular... Lisa, are you sure?
This question may have already been answered, but one of the topics could be what happens when the arbitrator believes there's collusion between the parties. And so whether it's for money laundering or some other purpose, so neither of the parties has raised it. The arbitrator has some suspicions, and maybe that's covered in one of the topics that already has been discussed, but it's a slightly different scenario where there doesn't seem to be a victim party. So is the analysis essentially the kind of analysis that we've already talked about?
I can start. So I think one of the potential answers to that is to go back to the merits of the dispute, to essentially ignore the existence of corruption by and large and have the parties address the merits. I had a similar dispute that I was actually parachuted into on the eve of the hearing a couple years ago. The parties spent 2 years arguing the merits and reached a settlement, but because of the identity of one party and their corporate governance rules that they had to comply with, they couldn't just sign off on a settlement out of concerns that there might be collusion between the parties, and the settlement was just a way of money laundering. So what the arbitrator in that case, what the arbitrator did in that case is he basically said to the parties, I don't care that you reached a settlement. I don't want to know anything about the parameters of the settlement that you agreed to. Come in front of me and put your best foot forward, both of you, and I'm going to make a decision fully within my discretion as to how I think this case should be decided. And that's what we did. We essentially converted the arbitration to a one-day hearing on the merits without evidence, without cross-examination, just basically relying on what was in writing on the record, the witness statements and expert reports, and making submissions to the tribunal, and the tribunal rendered its decision.
But if you've got a settlement, how does the arbitrator have jurisdiction?
Well, we essentially there was no settlement yet. The parties agreed in principle to the terms of the settlement and looked to get a consent award. But because of the corporate governance issue, one of the parties just could not proceed with that. So we defaulted back to essentially arguing the case in the merits again.
Thanks for a really interesting discussion. One scenario that hasn't been raised yet, I noticed scenario 3 kind of cleanly dodged it, is when acting as counsel, you come to believe that your own client is stone cold guilty of some kind of corrupt act, but the tribunal has not raised any red flags, and neither has the other party. What do your ethical obligations involve at that point?
Well, Josh, I'm actually happy to tell you that a prior version of of topic 3 included that exact issue. So well spotted. Does anyone want to make any comments on that? Well, so I think at least one of the starting points is obviously your professional obligations, right? And so, and in international arbitration, we have, you know, the interesting issue of people from different jurisdictions and representatives who may not be lawyers at all. So I think that the analysis, at least for the counsel, would be not necessarily dissimilar from the analysis that they would undertake, you know, if someone was in the normal course of their practice, and what are their professional obligations, you know, with respect to knowledge of a criminal act, but also with respect to vigorously defending your client, and the often tricky questions.
Thanks. Actually, just following up on that, I've had that situation come up, and I would say it's not just a matter of professional obligations, and it is related to comments that Bill made and that Mike had made as well, is that you as counsel and you as arbitrator are also subject to certain laws that flow according to your nationality, that flow according to your residency, et cetera. And so, for example, in the case where I was counsel, we actually had to have a discussion internally. We turned to our in-house general counsel, and we conducted an internal investigation of the client, which was incredibly awkward. You know, we communicated as best as we could to the client, explained, you know, here are our legal obligations. You know, my perspective was that it's in their best interest to fully understand this in order that we can manage the position in the arbitration and determine whether or not they would be exposed to potential legal consequences if they were to pursue the arbitration. Ultimately, there was a dispute in the executive table of the client. They decided to move to another set of counsel in another jurisdiction because those lawyers were subject to less stringent laws than we were with respect to the issue in question. And then they eventually lost the arbitration. And I think one of the reasons why is that they never really fully contended with some of the issues at play. But just one further comment in respect to what, and I think Lisa was getting there with her comment as well. Even if parties aren't raising a concern, I think if you see certain red flags as an arbitrator, again, the laws that apply to you may actually require you to engage in further inquiry with respect to those red flags. Right? So occasionally I am retained to advise arbitrators with respect to, for example, sanctions. There are, under Canadian sanctions laws, there are anti-facilitation clauses in there. You as an arbitrator could in fact be in a position in certain circumstances if a party is owned or controlled by a sanctioned person of running afoul of your legal obligations under Canadian law. So
And in a panel of 3, you could imagine, you know, each arbitrator may be subject to a different set of laws that require them to conduct themselves in a different way and maybe go further with an inquiry or not as far with an inquiry, which can present, I think, a whole host of other issues on a panel in determining what the right course of action is, as well as the necessary course of action to manage their own risk.
I'm wondering if there is an obligation at large within the context of an arbitration to make production of, in these examples, outside criminal convictions for corruption or widespread bribery schemes. If there isn't, it's a matter of contract and I suppose the procedural order. Is there any recourse if you don't have an obligation to produce the stuff? Maybe it's just not relevant at all.
I mean, I just say, sure, there's a limit to what an arbitral tribunal can do. I mean, and, you know, there are things like adverse inferences, there are certain tools, but maybe one of the, you know, one of the questions always is the extent of the evidence and the weight of the evidence, and it might be that the tribunal doesn't find the evidence and therefore cannot, you know, does not find it probative and doesn't go further. And I think that's certainly an outcome. And is that an accurate outcome, or is that a result of the lack of power or the failure to ask the right questions or the failure to ask the right questions of the right people? Who knows? But that can happen in domestic proceedings as well, I would say. Gary?
Sorry, I'm going to have to use my discretion as the as the moderator, and also just the organizers need to wrap this session up. But obviously we sparked some discussion, a lot to think about, and as always, you can continue the discussion or come up and chat with us after. So I think, Don.